Hello. Hi there. Hello. Big news in the Elizabeth Holmes case. So please hit that like button. So she did file her appeal of the court's denial of her stay-at-home request, her motion for release pending appeal. So that stays her surrender date, which was supposed to be tomorrow. So it'll probably be a couple weeks before we get a decision on that. As I've said all along, the Court of Appeal is likely to deny it. And at some point, Elizabeth Holmes will be surrendering to prison. However, I have the amicus brief filed by the National Association of Criminal Defense Attorneys who are supporting Elizabeth Holmes' appeal to throw out her convictions and to get her a new trial. So please do hit that like button. Please put a comment in the chat. If you want to join our chat, please do subscribe. And thank you for joining me. Thanks again for subscribing to Michelle's Analysis. So, hi there. I'm Michele Hagan. I'm a legal analyst and a former prosecutor. I have been following the Elizabeth Holmes case. I watched the trial. I've been given lots of analysis and lots of videos on this trial. It's a fascinating case, and now it gets interesting. As I have said, when we get to the appeal, it gets very interesting. So now we have a party that has nothing to do with this case, not a party to this case, but it is a group of defense attorneys who are saying to the Court of Appeal, they're stating their reasons why. So I'm going to go over their reasons why they're supporting that Elizabeth Holmes' conviction be reversed and she be granted a new trial. So I'll talk to you about what's not in this brief. What's not in this brief that they filed in support. And by the way, it's called an amicus brief, and that means a friend of the court, amicus curiae brief, which means it's a non-party that has filed a brief in support or in opposition. But in this case, and in this video, which by the way is for educational information purposes only, simply my opinion, do leave a question in the chat. I'll get to that. I have plenty of your questions. Thank you to those of you who have submitted. But okay, let me give you a little background here. Amicus curiae brief is a brief that's filed by a non-party that is given to the Court of Appeal, so that in this case, the Ninth Circuit Court of Appeal, which is the court that's going to be hearing the appeal by Elizabeth Holmes of her convictions and her sentence. I'm not talking about the denial that she just filed, appealing the denial of the stay-home request. The Ninth Circuit's going to be looking at that too, but that's a separate appeal. So in this video, I'm just talking about the amicus brief filed by a group of criminal defense attorneys who are claiming that her due process rights were violated and had a right to confront the confrontation clause. We're talking about the Fifth and the Sixth Amendment of the U.S. Constitution. Elizabeth Holmes was denied. Therefore, her conviction should be thrown out and she should be given a new trial. So, an amicus brief, it's called the friend of the court. Those briefs are filed by non-parties to assist the Court of Appeal in determining an issue. They provide information. And in this brief, what the National Association of Criminal Defense Lawyers who filed this brief in support of Elizabeth Holmes' appeal, what they have cited in this brief are studies. For instance, DNA evidence, right? Scientific evidence wrongly convicts people, wrongly convicts defendants. Okay, one example. But in this case, in the Elizabeth Holmes trial, their concern is over Dr. Doss's testimony, right? Watch my prior video I did when I went through the issues on appeal that Elizabeth Holmes is pursuing. I talked about Dr. Doss's testimony and whether it was proper for him to testify as a witness. And this appeal, this brief that was filed by the National Association of Criminal Defense Lawyers. Their concern is that Dr. Doss improperly testified as an expert witness and that he was able to testify to scientific evidence that was not verified. Therefore, Elizabeth Holmes was denied her due process rights and her right to cross-examine, to test the validity or the validity of the data that Dr. Doss relied upon. Dr. Doss in the Elizabeth Holmes trial testified that he reviewed the data and that his opinion was that the technology didn't work. So this brief turns on whether that expert witness testimony by Dr. Doss was improperly admitted. And that's again in support of what Elizabeth Holmes is claiming. She claimed that Dr. Doss should not have been able to testify should not have been able to give testimony regarding his opinion of whether her technology worked because, number one, the government, and this is also what's alleged in this brief, they're alleging that the prosecution didn't identify their expert witness in a timely manner, which they're required to do. And I got to look at my notes here. All right, so let me go through, what they're alleging in this, why they're concerned about Elizabeth Holmes' convictions. They're saying Dr. Doss's testimony was improperly admitted because he came in under the guise of being a lay witness, but he was actually an expert witness. And if he's an expert witness, there's a couple things that the prosecution has to do. Number one, they have to identify who their expert is in a timely manner. In this brief, the defense attorneys are alleging that Elizabeth Holmes, the defense was not told about Dr. Doss coming in as a witness. It was only 5 weeks before opening statement, well past the deadline in which they were supposed to identify their expert. And in fact, they identified a Stephen Masters as their expert, but they never called him. And there was never a hearing. It's called a Daubert hearing, in which defense attorneys are given and prosecutors are given the opportunity to test the credibility, to test the opinion of an expert, to test the qualifications. Because you don't want an expert coming in, somebody coming in, giving an expert opinion, and you're not allowed to test the data that they rely upon. And again, Elizabeth Holmes wasn't given the data. The government didn't provide any data in which Dr. Doss relied upon to give his expert opinion. And prior to when an expert takes the witness stand, you have an opportunity to test that expert, to find out what their qualifications are, to find out what their basis of their opinion is. But in this case, as these defense attorneys are claiming, and as Elizabeth Holmes claimed in her appeal, they didn't identify Dr. Doss in a timely manner. They're violating the federal rules of evidence because they didn't meet those guidelines, meet that deadline. They also didn't give the basis of Dr. Doss's opinion was a 4-sentence email. So when you identify an expert witness, you also have to give kind of a summary of what they're going to testify to. And why is that? Because you need to afford the opportunity of the defendant to confront, or actually to mount, a defense. If they're not given the data, how can they test? How can they know that the evidence is accurate? Right? How can you challenge it? How can you challenge the qualifications if you don't know about this expert, if you don't know what they're going to say? So they were given 5 weeks prior to opening statement. The prosecution identified Dr. Doss. The summary of the basis of Dr. Doss's opinion was a 4-sentence email. And the government didn't provide the data to Elizabeth Holmes to be able to challenge it. The data that Dr. Doss relied upon to give his opinion that the technology didn't work, that it wasn't viable for testing patient results. Okay. So again, please do hit that thumbs up. Please do subscribe to my channel. I'm going to get your questions. I'm looking at the chat here. Yes, surprise, surprise. And speaking of surprise, the government, the prosecution isn't allowed to surprise defendants. You're supposed to be told of, the expert, what they're going to testify to, allow them to challenge the qualifications, allow them to challenge the data. But that didn't happen in Elizabeth Holmes' case. All right. So let me get to, in particular, what the defense attorneys are claiming. And this is the National Association of Criminal Defense Attorneys, criminal defense lawyers, the largest organization in the United States. It's comprised of public defenders, private criminal defense attorneys, judges, professors. It's a large organization, and they have a concern. And all the parties, Elizabeth Holmes and the prosecution, allowed this amicus brief to be filed. They were notified, they were consented to being filed. And this brief is giving information to the court, specifically studies and other cases in which convictions were reversed or expert witnesses were not allowed to testify because the prosecution didn't meet the deadline in disclosing who they were going to call in a timely manner, or didn't disclose the data on which the expert witness relied upon, or didn't disclose the basis of the opinion. All right, so let me get to your questions. What legal rate, what legal rate other than happy, I'm not going to read it. Okay, testimony should be nothing more than an option, either expert or not. No, it's a big deal. If an expert witness comes in, the government has to meet certain requirements. Number one, identify who it is. Number two, what are they going to say? What's the basis? Number three, if they're relying on data, they need to present the data to the defense. Why? Because the defense has a right. It's called due process. They need to be given notice. Notice, who's this expert? What are they going to say? They need to be given an opportunity to challenge qualifications, the opinion of the expert, because if they're not qualified, they shouldn't be testifying. And if they're going to give scientific evidence, scientific testimony, right, which is giving an opinion, which is what Elizabeth Holmes is claiming. I'm not saying this is true. I'm just pointing out their positions. What Elizabeth Holmes is claiming and what this amicus brief on behalf of the National Association of Criminal Defense Lawyers is claiming, that data, she wasn't given it, so she's not able to challenge, right? But yet the jury is allowed to rely on that data. That's basically unverified data, right? It's not examined, it's not challenged. Because if we think the data is sketchy, or we think an expert witness isn't qualified, then we have the right to prohibit, to stop them from testifying. But if you're not given that opportunity, then do you have a fair trial, right? It comes down to fundamental fairness of, did Elizabeth Holmes get a fair trial? She wasn't provided the information. She was told about the expert late. She wasn't given the summary of the 4 sentences of what Dr. Doss would testify to. And whether or not, this turns on whether or not Dr. Doss is an expert witness or a lay witness. All right. And as pointed out in the prior video I did on why Elizabeth Holmes is appealing, she's pointing out that Dr. Doss actually testified as an expert witness. He was giving scientific or specialized knowledge, right, based on his experience as a lab director, looking at the technology, looking at the Edison analyzer, determining whether or not that technology worked, right? In his opinion, it didn't work. And what did he recommend to Elizabeth Holmes? That she void all those blood test results, those 50 or 60,000 blood test results. All right. Like I said, I pointed this out to you in the last video. Don't underestimate Elizabeth Holmes, all right? And this issue of whether that expert witness testimony provided by Dr. Doss, or even Dr. Doss's entire testimony, should have been admitted is a concern of the National Association of Criminal Defense Lawyers, right? And also Elizabeth Holmes. Okay, so let me see what else is in the chat. Paul Wilson, even crediting everything that Holmes' team is true, which I'm not, there is harmless error. That's a good question. So Paul, as I pointed out in my last video, the test here is prejudicial error. So in other words, just looking at the issue of whether or not Dr. Doss's testimony was properly or improperly admitted, does that arise to prejudicial error? Did that significantly impact the outcome, the verdict? And again, that's a call for the Court of Appeals to make, right? Those three judges, this panel of the three judges will determine whether or not it's prejudicial. Could it be harmless error? Well, I can tell you this much. If it's a question of whether Dr. Doss, a concern that the National Association of Criminal Defense Lawyers has in pointing out the specific issue, that expert witness testimony and that scientific evidence, that his opinion that the technology didn't work should not have been admitted, and it violated Elizabeth Holmes' due process rights and her right to confront or cross-examine cross-examine Dr. Doss about what data he relied upon to come to that conclusion. Can you imagine going to the doctor giving you an opinion, and you can't ask, well, how did you come up with that opinion? Now, I know this might be a gross overgeneralization, but I just wanted to point that out. And when a witness becomes an expert witness, there's certain requirements that are required to be fulfilled. Identify him, who the expert is going to be. They identified Steve Masters. They called Dr. Doss. Tell us what the basis of the opinion is. It was a 4-sentence email. There was no Daubert hearing, which is your opportunity to challenge the qualifications. Before this witness takes the stand, you have a right to challenge an expert's qualifications, the basis of their opinion, and the information that they relied upon. All right? So I base this on all other evidence. Yeah, well, but you can have all that other evidence, but if the court finds prejudicial error, out goes the conviction. Okay? Data was a moot point. No, it's not a moot point, according to this amicus brief and according to Elizabeth Holmes. The Theranos machine didn't work. Well, if you read the appeal filed by Elizabeth Holmes, there was 8 million, according to them, there was 8 million blood test results. And Elizabeth Holmes was only charged with 4 counts related to the patient counts. Okay, are you following me on that? Right? So if I was, I was a prosecutor, done a lot of trials, maybe an argument could have been, hey, there were 8 million results and they're only saying that they goofed on, actually it was 3 patient counts, right? And in particular, those counts relate to Aaron Tompkins, the false HIV test, Merrill Ellsworth, the false prostate results, all right? And then there was BB, who was also another one. That did not come in. That count was dismissed. So what if this case gets sent back for a new trial and Dr. Doss is not allowed to testify as an expert witness? What happens to the patient counts? And by the way, can she be retried on those patient counts? She was tried and acquitted. Out goes the patient counts. So what are we left with? We have the investor counts. So she's not charged with 11 or 12 counts. She's looking at potentially 7 counts. If those acquitted counts, she can't be retried on because of what? Double jeopardy. Okay. All right. Let me look at the chat here. Holmes has fundamental rights. Yes, she does. But what will the prosecution say? Again, yeah, I don't know. I haven't seen the prosecution's response yet. It hasn't been filed. This video is only pertaining to what the defense attorneys, the defense lawyers are claiming that constitutes or justifies reversing Elizabeth Holmes' convictions and giving her a new trial. Has the prosecution responded? Nope, not yet. Thank you, Paul Wilson. Are you calling for 8 million depositions? No, I'm not calling for 8 million depositions. I'm just pointing out that, if they're going to retry her, she could be looking at new charges. Maybe they're going to file some new patient counts. I don't know. But on those patient counts, if the jury, she was tried and she was acquitted on those counts. So that leaves us with, I don't know what they're going to do on if it gets to a new trial, because I have said all along, in order for it's not easy to win an appeal, right? Elizabeth Holmes has to show prejudicial error. That's not an easy test. It's not just harmless error. It's not just a mistake. But when you're dealing with expert witness testimony, the court can get very concerned. And when you're dealing with, potential violation of constitutional rights, of due process or confrontation clause, the ability to cross-examine an expert on their opinion, when you're dealing with violations of the constitutions, that is very concerning, right? And again, these are just allegations. We don't know yet. But why? Why? Let me read this to you. The statement in the amicus brief, there's reasons why I'm looking for my notes here. Hang on a second. I got too many notes in front of me. So the reason you don't want to be surprising, the reason that when you call expert witnesses, there's so many requirements, is because you want to give a defendant an opportunity to defend themselves, right? And due process means notice of who you're calling and what they're going to say. And in this amicus brief, they cite to studies, right? Again, this brief, friend of the court, is providing the court with additional information, studies, and cases that the court can consider in their decision, in their evaluation of this appeal. So they say that scientific evidence is more influential to jurors, right? Therefore, it could have an impact on the verdict. It presents a unique risk of prejudice to the defendant. It also bolsters the credibility of an expert, right? And it is definitely seen as more influential to a juror, but it could also mislead a jury, because they could think an expert has higher, maybe they should be putting more weight on that evidence or that testimony of Dr. Doss more than any other witness. And they also talk about 25% of a jury, 25% of jurors have said that they would have changed their verdict. 25% of jurors have said in a study that they cite in this brief, 25% of jurors would have changed their verdict if scientific evidence was absent. In other words, they needed the scientific evidence, the testimony of Dr. Doss in this example, or in this brief. They would have needed the testimony of Dr. Doss to conclude or to come to their decision of a verdict. So it's very interesting. And yet that's exactly what Elizabeth Holmes was not allowed to challenge or cross-examine, I should say, Dr. Doss on his opinion that the technology worked or that it was accurate in dealing with patient results, because Dr. Doss at the Holmes trial was presented as a lay witness. And a witness becomes an expert witness when they're giving specialized knowledge or scientific evidence. And when you give an opinion saying that technology does not work, is not accurate, then these defense attorneys and Elizabeth Holmes is arguing that makes that witness an expert witness. And if that witness is an expert witness, the prosecution failed to do the following. They failed to identify Dr. Doss in a timely manner. They failed to provide they provided the notice of Dr. Doss testifying 5 weeks before opening statement, the summary of what the expert, Dr. Doss, was going to say, the alleged expert, Dr. Doss was going to say, was only a 4-sentence email. And the data that Dr. Doss relied upon in giving that opinion was not given to Elizabeth Holmes. So she wasn't able to check to see what the data, if it was verifiable, if it was reliable, right? And that all comes under the fundamental fairness, the notions of due process rights that Elizabeth Holmes, like every defendant, is entitled to. Okay? So, Lindsay, hi, Lindsay. I remember the judge saying something on the lines that the test results aren't as important as the fraud. Yes, that's a very good point, Lindsay. That takes me to my next point. My next point is whether or not the technology worked is only one of the several misrepresentations that the prosecution alleges in their indictment. In the trial, I was there. In the trial, they also said that Elizabeth Holmes misrepresented the financials, right? That Elizabeth Holmes misrepresented using the Theranos devices when they were using third-party devices. Elizabeth Holmes and Sonny Balwani misrepresented the relationship with Walgreens in the Department of Defense. Was the analyzer used in the field? Was Walgreens stalling out opening up their wellness centers? In the court, in the court's previous opinion denying the right for her to stay at home, was that the allegation that the case doesn't turn, I'm paraphrasing, the case doesn't turn on the allegation regarding whether or not the technology worked, because there was all these other misrepresentations that she made. But as I said in the last video, and as Elizabeth Holmes is arguing, the core allegation, okay, again, I'm just playing devil's advocate here. The core allegation, and I'm not saying I agree with this, the core allegation is whether or not the technology worked, right? So are we going to say that the investors invested in Theranos because the relationship with Walgreens, the department, doesn't the technology have to work? And that's exactly what Elizabeth Holmes has set out to prove, that her technology worked, okay? So again, hit that thumbs up. Any questions, go ahead and drop them in the chat. All right, so let me get to other points here. Let me see if I covered what I wanted to say here. So, was it a trial by ambush, as what the criminal defense attorneys have put in their brief? Was Elizabeth Holmes robbed of those protections of the evidence code, of being timely disclosure of an expert witness, timely disclosure of what they're going to say, being able to verify that the data is reliable? Was her due process rights violated? Was her right to confront a witness, the confrontation clause, the Sixth Amendment of the Constitution, was that violated? This appeal turns on whether Elizabeth Holmes, turns on whether Dr. Doss, when he took that stand, did he testify as an expert or did he testify as a lay witness? And if he testifies as an expert, did all these requirements get fulfilled? The defense attorneys say no, prosecution failed. Elizabeth Holmes has said the prosecution has failed. Okay, but what's not in this brief? Their concern is solely related to the expert witness testimony of Dr. Doss. They're not saying anything about the voided test. They didn't say anything about the CMS findings. They didn't say anything about Balwani's SEC testimony, which wasn't allowed in Elizabeth Holmes' trial. None of that is in this amicus brief. Their concern, the National Association of Criminal Defense Lawyers' concern, is solely on the expert witness testimony. Why? Because juries rely on experts more than any other witness. Juries are influenced by experts more than any other witness, according to the National Association of Criminal Defense Lawyers. They cite to DNA evidence. And in particular, when they cite to the DNA evidence, I've got to get to my notes here. They say that many times defendants are wrongly convicted because DNA evidence, like scientific evidence, like Dr. Doss gives an opinion whether or not scientific, the Edison worked, whether or not that, that was influencing the jury or not. And whether, defendants are not supposed to be surprised by evidence, right? And they're supposed to be allowed to challenge it and to challenge experts, to challenge opinions. But if Dr. Doss is a lay witness, then all of this concern goes out the window, okay? And this is a call for the Court of Appeals to make. It's for them to decide. All right, so their concern in this amicus brief is whether or not Dr. Doss's testimony should have been admitted should have been kept out because he was actually an expert witness dressed as a lay witness, right? And so there's a statement that in the amicus brief, I want to get to it, and I'll read it to you. In particular here, why did the National Association of Criminal Defense Lawyers raise this issue? They're raising this issue and they want the court to rule in Elizabeth Holmes's favor. And they're pointing out this concern to the Court of Appeals because it's a useful vehicle. This appeal is a useful vehicle to send a strong statement to discourage the government from continuing to circumvent rules of evidence by funneling expert opinion through lay witnesses. In other words, they put Doss on, they call him a lay witness, right? He's just testifying to things that he observed at his job, not giving specialized knowledge that would make him an expert witness. But they dressed him as a lay witness, and he actually gave expert witness testimony, which they say was improper, okay? So in other words, Dr. Doss was allowed to testify to improperly admitted and unqualified scientific evidence, which is in violation of due process and the confrontation clause, okay? So is everybody following me on that? Holmes... Yes, you can say that, I hear what you're saying, Pictor, that Holmes the eternal victim. Or she, like every defendant, has the right to appeal her convictions and her sentence. And if the prosecution goofed, if rules of evidence were violated, or if due process was violated, or confrontation clause were violated, then convictions can get tossed. And the case can be sent back to the trial court for Elizabeth Holmes to get a new trial. On what counts, we'll find out if that happens. But it's a tough burden. It's a steep climb up that hill for Elizabeth Holmes to show that prejudicial error occurred relating to the alleged expert witness testimony of Dr. Doss. Okay, so let me look at how are we doing on time here? I want to show you talk to you about some of the studies that they refer to in this amicus brief, which is why I'm sure the court allowed this brief, and all the parties are consenting to this amicus brief, is to provide additional information to the Court of Appeal. Okay, so, they talk about the need for federal courts I'm citing from the amicus brief. The need for federal courts to act as gatekeepers for expert scientific testimony is even more critical today. As such, technological advances makes expert evidence, in other words, Dr. Doss's testimony, expert evidence more influential on jurors than in the past. For this reason, courts have recognized that expert testimony creates an undue risk of prejudice to the defendant. Okay? And it also gives potentially undeserved credibility of Dr. Doss. And it could mislead the jury because studies have shown that jurors rely on expert witnesses more than they do other witnesses. And they specifically refer to DNA evidence as an example. DNA evidence, in cases regarding DNA evidence, expert testimony in DNA cases, expert testimony is the second most common contributing factor to wrongful convictions. In DNA cases, expert testimony, that's the person that comes in, the witness, the expert witness that comes in and talks about all the analyzing of the DNA, think about the Brian Kohlberger case, right? The DNA, it lines up with his the paternal genealogy in his I should say, how do I say this? That the blood that they found at the Idaho college murders lines up with the DNA collected from the trash, right, out of his parents' home, relates to his father, and that would relate to his son. Okay? So they're saying expert testimony in DNA cases, second most contributing factor to wrongful convictions. So, Dr. Doss's testimony, scientific evidence, expert testimony, did it contribute to the wrongful conviction of Elizabeth Holmes? Should Dr. Doss been prevented from testifying? Should Elizabeth Holmes been allowed to cross-examine Dr. Doss on his qualifications on the basis of his opinion? Verify that the data that he was relying on, it was never provided. Okay? So they also said that another study examining the effects of expert testimony in cases where defendants were later exonerated found that flawed expert evidence was involved in 60% of false convictions. 60% of the time, convictions were false because of flawed expert evidence. That's what they're talking about as a study. And again, I'm just going over some of the studies that they have provided to the Court of Appeal to consider. If the Court of Appeal decides to, it's in their discretion, they could give credence to this amicus brief, or, could weigh in their decision or not. It's up to the Court of Appeal to decide that. Okay, so they don't want the abuse or misuse of expert testimony. And they want to protect the due process rights of defendants, and that the government is required to provide a writing, something written to the defense of all the opinions that the expert witness intends to present, the basis for the expert's opinion, sufficiently before trial to allow a defendant a fair opportunity to mount a defense, to minimize surprise, to give the defendant a fair opportunity to cross-examine this witness. And the defense attorneys in this brief, and Elizabeth Holmes has also claimed that the prosecution failed to do that. Therefore, rules of evidence were violated. Her constitutional rights were violated. And she wasn't also allowed to present any rebuttal expert witness herself, because if she doesn't know where's the data for some expert that they could call to rebut if their data wasn't provided. Okay, I hope this is following. How are we doing? The jury did not convict Holmes on patient they didn't convict her. They acquitted her on the patient counts. The expert opinion did not sway the jury. Well, that's a good question, because Dr. Doss, if those acquitted counts, due process, those particular patient counts, she could be charged with other patient counts. We don't know if this case gets remanded for a new trial. But the patient counts were acquitted, double jeopardy. She can't be retried on those counts. So maybe it's just going to be focused on what she said to the investors, right? So maybe we don't care what Dr. Doss has to say regarding the voiding of the test results or his opinion of whether the technology worked. Maybe it's relating solely to the representations that Elizabeth Holmes made to the investors if they proceed only on investor counts, which is what she was convicted of, the one count of defrauding investors, conspiring to defraud investors with Balwani, and then the 3 counts of defrauding individual investors. The jury came back hung undecided on 3 other investor counts. So it could be a whole new case, a whole new shot for both the defense and the prosecution if it gets sent back to a new trial. Theranos was using conventional machines to produce analysis. Well, according to testimony in the Elizabeth Holmes third-party devices, and I think Elizabeth Holmes also testified that the third-party devices were modified as part of their trade secret, right? So it wasn't disclosed to the investors. So let me see what else I have here. Let me cite to a couple of these cases. There was a case where the prosecution failed to provide the expert witness. I think it was within 8 days of the deadline. The court prohibited the expert from testifying. On another appeal, actually that was 5 days before trial, the expert was kept out, could not testify. The prosecution, I'm citing the cases that are in this brief. Prosecution failed to provide the laboratory report in a timely manner, and the prosecution's expert was excluded from testifying because that was a violation of discovery and of the federal rules of evidence. And then a government's expert witness testimony was excluded because the government knew about certain issues 2 years prior to this, but didn't provide it as part of discovery. So that conviction was reversed. There's another case, United States versus Valencia Lopez. The court reversed a conviction where the government failed to disclose any data or the basis of the expert's opinion. Interesting, very interesting. The court reversed the conviction. Another one was a 2001 case where the court set aside the conviction because the witness was offered under the guise of a lay witness, but was actually an expert witness. Here's another case, 2003. The government failed to designate a witness as an expert. Another case, 2013. These are all appellate cases. The court reversed the conviction and remanded a new trial where a lay witness presented specialized and technical testimony, which is exactly what Elizabeth Holmes and these defense attorneys are arguing. Dr. Doss's testimony amounts to specialized knowledge and technical testimony. Therefore, he's an expert witness. Therefore, the prosecution failed to meet all the requirements that they're required to, and therefore her conviction should be thrown out. In that case, the plaintiffs didn't receive all the photographs of the physical evidence. In other words, the verifiable data, which is what Elizabeth Holmes is claiming. Okay, so let me see what else comments you have here. Richard. Hi, Richard. To suffer the slings and arrows of outrageous she'll walk. Well, as I said in the prior video, she's got some traction and some interesting points here. Interesting points on appeal. But when it comes to expert witness testimony, when it comes to scientific testimony, That is definitely can be a concern on appeal. And that's exactly, I think, exactly why these Association of Criminal Defense Lawyers filed this amicus brief. They didn't have to say anything, but they filed an amicus brief. They're also supporting Elizabeth Holmes' request to have her convictions thrown out. And specifically, they're supporting Dr. Doss's testimony was improperly admitted and the data was not verifiable that supported his opinion, and the prosecution failed to disclose him as an expert witness in a timely manner. Therefore, she's entitled to have her convictions thrown out, and she's entitled to a new trial. Okay, so let me look at your questions here. Hi, Ignacio. How are you? Do subscribe, you guys. Do subscribe to the channel. Support my work by subscribing. Oh, and by the way, if you want to super chat me and contribute to me making these videos, I put a PayPal link in the chat box and the description box below the video. Thank you to all of those of you who have subscribed. I really appreciate it. Please do support my work by subscribing. Let me get to some of your questions here. I'm looking for the questions that you submitted, and thanks to all of you for submitting your questions. And they are David Anderton. Thank you, David, for your question. As expected, Holmes's appeal, denial of the motion for release at last moment, will delay her prison for as long as possible. Look, this just takes time, okay? I know the media likes to make a big deal about all this. I get it, but this is a process. Elizabeth Holmes, like every defendant, and Sunny Balwani did this too. They both appealed the denial of their right to stay at home, the motion for release pending appeal. In other words, to stay out of prison and waiting for the Court of Appeal to make their decision, which, by the way, could take anywhere from 18 months to 2 years, depending on the caseload of the Court of Appeal, to determine whether to uphold the convictions or whether to reverse Elizabeth Holmes' convictions and Sunny Balwani's. But Sunny Balwani was tried separately. He's filed a separate appeal. This amicus brief does not relate to Sunny Balwani's trial. It's only in support of Elizabeth Holmes, okay? So, Kay Shaw says, I don't remember at her trial was some evidence of the machines destroyed by her staff before she left Theranos. Well, wouldn't that be something the prosecution should have mentioned? Well, as far as it was kind of limited testimony regarding the LIS, all the database testimony. Because the database was provided to the prosecution, but they weren't provided with the code because it was encrypted. So they never got into the database. They didn't see whether or not it was helpful or incriminating evidence towards Elizabeth Holmes. And, there was a whole motion on that as to whether or not the defense or the prosecution could get into that. And so what the jury was told, was that there was a database and it wasn't, they weren't able to get, weren't able to make use of it. But the court wasn't, I think the court's reason is they didn't want to have a whole nother trial about what happened to the database. Okay. But the question here is whether what was Dr. Doss relying on when he gave his opinion that technology doesn't work, right? What information did he know in 2015 or 2016 when he gave the opinion? And by the way, all these counts relate to conduct during or alleged representations made, misrepresentations, 2010 to 2015. Dr. Doss has looked at the what data was he relying on in 2016? What data was he relied upon when he took the stand and gave that opinion, right? That the technology didn't work. Kay Shaw says, why didn't her lawyers say or do something during the trial? They did. They objected. And they also did in motions in limine before the trial. It looks like a last-ditch effort on her part. Well, like any defendant, and according to these criminal defense lawyers, it's an area of concern, and the court should take notice, and the prosecution should be sent a strong statement that they are not allowed to circumvent the rules of evidence by funneling expert opinion through, using or funneling expert evidence through, supposed lay witnesses. Okay? They are concerned, and this is an organization that's on the front lines of reforming the criminal justice system. All right, let me see what other questions I have here. Fungi. That's what Balwani did also. Yeah, unreadable encryption database. Yeah, I think there was. Yeah, sounds legit. Yeah, that's an interesting comment. Okay, so Aussie Girl asked a bunch of questions. Did Dr. Das testify in Balwani's trial? I believe he did. Yes, he did. I'm assuming his lawyers either overlooked this. Well, I haven't seen what Balwani's appeal is. It could be the same issue. I don't know why the government took such a risk. This is according to Aussie Girl, not me. I don't know why the government took such a risk, or the judge on this one, since I think they probably had enough to convict without Dr. Das. Well, the prosecution, I'm sure, is going to say in their response to these claims is that Dr. Das testified as a lay witness. He was just testifying to what he observed at work. It's part of his job to be looking at what the Edison is doing. He wasn't giving any scientific testimony. He was just giving testimony of what he observed as a precipient witness, what he observed at Theranos regarding the technology. Okay. Let me see. Jackie C., thank you for subscribing. Thanks for all your information. You're welcome. I think it looks pretty good in Elizabeth's favor. If she gets a break, good for her. Well, I think some would agree, and I think some would not agree. Manchita said, well, what a surprise. I knew she would not go down easy. As I said all along, she's a fighter. You got to know who's in front of you here. Come on. She left Stanford, spent many years in stealth trying to get this technology together, trying to get the whole business, the blood testing company at Theranos. She rolls it out. I think it was in 2013, right? In 2018, she gets indicted, right? So, and she's fought it all along, as has Balwani. She raised millions of dollars. She had many investors who relied on her representations and Balwani's. They invested in Theranos because they believed, I'm sure these investors believed, that this technology, just on the prick of your fingertip, a drop of blood could change everything. That drop of blood would allow them to run a whole host of blood tests. She was revolutionizing, innovating the healthcare industry. She believed in her technology. Belief is not a fact, okay? She believed. According to Dr. Das, it didn't work. According to Erica Chung, it didn't work. According to Tyler Schultz, you can look at the video I did on his scatter plots that he sent to Elizabeth Holmes, showing that the results were not reliable. That's what they testified to, and that the jury convicted her. Convicted Elizabeth Holmes of defrauding investors, of defrauding 3 individual investors, acquitting her on the patient counts, and the jury hung on 3 investor counts. They were undecided. Jamie Kavanaugh said, will there be, so is there going to be a new trial? We don't know yet. It's a tough burden. Does that mean she's not going to prison? No. She's not going to prison tomorrow, which was her surrender date, because today she filed her appeal of the court's decision to deny her request to stay at home pending appeal, just like Balwani did. So let's assume, as it happened in Balwani, it takes the court a couple weeks. Court of Appeal comes back with the decision. If they deny, or actually, if they affirm the lower court's denial of the stay-at-home request, then Elizabeth Holmes has to surrender to prison. If they reverse, or they overrule what the Court of Appeal, what the lower court did, denying, then Elizabeth Holmes doesn't have to surrender to prison. She can stay at home. So let's assume that the Court of Appeals upholds what the lower court does, denying her an opportunity to stay at home pending appeal. Then I think Elizabeth Holmes is going to do what Sunny Balwani did. She's going to come into court. She's going to ask the court for additional time to get her affairs in order, just like Balwani did. Maybe it's a couple days, maybe it's a week or so. At that point, the court will determine a date for her and the Bureau of Prisons, a date for Elizabeth Holmes to surrender to prison, just like Balwani did, and Balwani's in prison. He surrendered, wasn't it last week? I don't know. It's been a crazy month. Balwani's in prison awaiting decision. My opinion, Elizabeth Holmes is probably going to be in prison awaiting the Court of Appeals opinion on whether to uphold or reverse her convictions. Okay. Will there be additional amicus briefs? Are other groups going to come in and support Elizabeth Holmes? Are other groups going to be filing amicus briefs to give the Court of Appeal guidance, to give the court additional information for them to consider on whether or not they deny, reverse or uphold Elizabeth Holmes' convictions? I think there may be additional briefs being filed. Just a guess. Never a dull moment. All right. Fungi. Oh, appealing Alex. Elizabeth is just twisting. No, she's not twisting the system. She's pursuing the system just like everyone else. She's testing the system. That has been lenient on her. I don't know about lenient. 11 years? I mean, most rapists don't go to jail for 11 years. 11 years and 3 months? Those sentencing guidelines, it was because that amount of loss took her down those 10 years. She got an additional 27 months because there were 10 or more victims. And again, this amicus brief is only dealing with one issue that Elizabeth Holmes raised in her appeal. It's only dealing with the expert witness testimony of Dr. Das. It is not addressing whether or not Balwani's SEC testimony should have been admitted. It doesn't address whether the voided testimony should have been admitted. It doesn't address whether the CMS report findings should have been admitted. It's not challenging any of that. It's only challenging the expert witness testimony of Dr. Das, whether or not he was an expert or whether he was a lay witness. Okay, fungi. If she got denied, how long can she be requested to stay free to get her affairs in order? That's up to the judge. Balwani fought he's sleeping in prison anyway. Well, Elizabeth Holmes is going to fight. I mean, think about a person who drops out of Stanford based on her beliefs that she can change the healthcare industry, and she does it. She does it in the sense that, I mean, I know the jury found it was fraud, but she started a company. A 19-year-old starts a company, raises hundreds of millions of dollars, gets what, a $4 billion valuation? I know the jury found it was based on fraud, but what kind of person is able to do that? And is that person going to sit down and take convictions? No, they're going to fight. They're going to fight. As every defendant and every criminal defense attorney will tell you, you pursue all avenues. I did too. You pursue all avenues. If constitutional rights were violated, you pursue it. If a witness shouldn't have testified because they were actually an expert witness, you should challenge it. That's the way the criminal justice system works in the United States, with protections by the Constitution of due process. You can't sandbag a defendant. They're supposed to be given notice of who the prosecution, and again, 5 weeks before opening statement, the prosecution did give notice. Question of whether or not it was timely or not. That's something they're contesting. They did give notice of Dr. Das. Did they provide a summary of his opinion? Yes. They gave a 4-sentence email. Did they provide the data on which his opinion was based on? No. Should they have? Well, that's up to the Court of Appeals to decide. Yeah, she named her daughter Invicta. And by the way, I'm going to be doing a video after this on just the name Invicta. Okay? So, any other questions? Any other questions from any of you? Anything else? Please do hit that thumbs up. Please do subscribe to my channel. And so where we're at now is there's an amicus brief that the Court of Appeal can consider or not. It's up to them. Filed by the National Association of Criminal Defense Attorneys, the largest criminal defense association in the United States, that has a concern and is asking and is supporting Elizabeth Holmes in her appeal based on just Dr. Doss's testimony. They're saying that if you qualified as an expert witness, the prosecution failed to meet the requirements, that Dr. Doss should not have been able to give that opinion if Elizabeth Holmes wasn't able to verify the data, that it brings up questions of whether her constitutional rights of due process and confrontation clause, the ability to cross-examine Dr. Doss regarding his opinion or challenge the data, the verifiable, unverified data that he relied upon, whether or not that violates her constitutional rights. Okay? So we don't have the government's response yet to Elizabeth Holmes' claim. And again, go ahead and watch my video I did on why Elizabeth Holmes is appealing, because there's several other issues that are not being raised in this amicus brief by these defense attorneys. But there may be some traction there. Don't underestimate these arguments, these points. Yes, can't wait for prosecution's response, Victor. I see. Appealing Alex pays nothing, system is in her favor. Well, think about the system that we have in criminal justice. There's a lot of safeguards that are there so that defendants are not wrongfully convicted, right? So, there's I guess I put a comment, or I put a poll on our community page that I encourage all of you to take a look at. It's whether prosecutors, right, can be terminated or I should put it this way, whether prosecutors have a First Amendment right to not charge, to not pursue certain crimes. Go ahead and vote in that poll. I'm curious, because there's a case pending before the 11th Circuit Court of Appeals based on a prosecutor in Florida who was, I think, suspended by the governor because, according to the governor, the prosecutor wasn't pursuing certain kind of cases. It's more complicated than that, but go ahead and take a look at my poll and do vote. Can't wait. Okay, so any other questions from any of you? All right. Any other evidence does matter. The rules of evidence do matter. We do have rules that people have to abide by. And when those rules are violated, convictions can be put in jeopardy. All right. So whether or not Elizabeth Holmes was, whether it was a trial by ambush or whether she was robbed or whether it was a sleight of hand, all those terms that were referred to in the defense attorney's amicus briefs, and whether the government skirted the rules of evidence, that's up to the Court of Appeals to decide. Okay? So next up, we'll see what the government has to say. Hopefully I'll have an opportunity to analyze that too. And we'll see if any other amicus briefs are filed in support of Elizabeth Holmes' request to have her convictions reversed and to get a new trial. What the outcome of that will be, we'll have to see. But at this point, she is staying at home until the Court of Appeal. She's not surrendering to prison tomorrow. She's staying at home or out of prison until the Court of Appeal renders a decision on whether or not the court made a mistake or not in denying Elizabeth Holmes' right to stay at home pending appeal. As I have said, I think the Court of Appeal is going to uphold with the denial, and that Elizabeth Holmes will be surrendering to prison, I'm guessing sometime in June or July. All right, so hit that thumbs up. Thank you. Thank you to all of you who've joined me. Thank you to all of those of you. I swear it feels like Friday. To those of you who have been subscribing to my channel, to our channel, Michelle's Analysis, I appreciate you, all of your analysis, all of your keen insight. Hi, Catherine. Is her conviction is overturned? Does that mean she? Yes. If her conviction is overturned, she gets a new trial. Yes. Yeah, or is she? Okay, thank you, Michelle. You're welcome. Can prosecution pursue house arrest? I don't know what you mean by that, but it's home detention. In other words, she's out of prison. Are they going to arrest her and put her in custody? No, because she's been out on bail. Okay, so it's just a question of whether she surrenders to prison tomorrow, which she's not going to be because she filed an appeal. And so that means she's free on bail, or in this case, free on bond, until the Court of Appeal makes a decision on whether or not she needs to surrender or whether she can stay out of prison pending the appeal. My opinion, she's going to be surrendering to prison shortly. Okay, so I don't know if it's June or July, but I think she's going to lose at the Court of Appeal on her denial of the stay-at-home request, her motion for release. I think she has some traction on her appeal, and getting an amicus brief from the National Association of Criminal Defense Lawyers, that's very helpful. Whether it's persuasive to the Court of Appeal, we'll have to see. All right. Thank you, Jaku. Thank you for joining me. Yes, thank you. I appreciate it. Thank you for all your comments. Please do subscribe, share this video, hit that like button. If you want to contribute to me making these videos, hit that PayPal link. I put a PayPal link in the chat box and also in the description box below the videos, below the video. Okay, and I encourage you again, read the appeal, read the amicus brief, interesting issues, and don't underestimate Elizabeth Holmes, okay? And anything could happen. I've always said there's surprises, right? Here's one of them, that we have a National Association of criminal defense lawyers weighing in on this case. Why? Because they care about the fundamental fairness. They care about the criminal justice system providing fair trials to defendants. And when they see, they speak up. And in this case, they're speaking up on just the concern regarding the testimony of Dr. Doss. Did he testify as an expert? Or did he testify as a layperson? Okay. All right. So thanks again for watching. Thanks for joining me for this live. I appreciate you supporting my channel and hitting that like button. Please do leave a comment. I want to know what your analysis is, because we are analyzers. We think about things. We don't take someone's opinion as fact. And beliefs are not facts, and words do matter, okay? Check the information you're provided, right? Check it. Trust but verify. All right. Anything else? Anything else? Keep tabs on my comments that I post. I don't always have time for videos. You may want to go and scroll through some of the comments. Vote in our poll whether prosecutors have a First Amendment right not to pursue certain crimes, certain cases. I want to know what your vote is. Yes, beliefs are not facts. Elizabeth Holmes believed her technology worked and believes her technology works. The jury heard the evidence and the jury found that she committed fraud. Okay? So we'll see what the Court of Appeal does. We'll see if they overturn her denial and she can stay at home while the Court of Appeal is considering her appeal of her convictions. Again, those are two different appeals. She's appealing her convictions and her sentence. Court of Appeals is going to look at that. She's also appealing the judge's ruling denying her opportunity to stay at home pending the appeal. Okay? So we'll see what happens next. So stay tuned. Thanks again for watching. Thanks for joining my live. Thank you for everybody in the chat. Nice to see you all. Thank you for all your comments, your questions. Thank you for all your support. Thank you for supporting Michelle's analysis. Have a nice weekend.